Hey Liz, it's muted, I think. I still can't hear anything.
Speaker.
Oh wait, no,
Oh, yeah.
sorry. Yeah, I hear you. Thank you.
Oh no. that terrified me. Wow. Yeah, I didn't expect it to come through that speaker. Like, also, I've been sick for like a week, so I've been spending my week reading all sorts of like ridiculous, spooky novels because it's raining and that's what the library has right now, you know. And like, fuck. All right, we're super serious again. We're so serious. Yeah.
What's the definition of errant counsel?
Errant counsel. So if you're being errant, you are going against what you're supposed to be doing. You're behaving errantly. So when attorneys misbehave or get a little too dramatic or don't follow proper procedure, all that kind of stuff, you are basically their boss. You have to control the entire courtroom. And you have to do that in ways that, again, maintain impartiality and dignity. You have to do that in ways that are graceful and kind, or also firm when need be. The book authors have very kind of put judges on a pedestal. So a lot of this is, the language from your book is pretty strong around you know, discussing the need for judges to keep their work at work and to not wear the robe at home, so to say, and all that kind of stuff. The same with any kind of job within the criminal justice system. But judges do have a lot more authority than other types of jobs, and so there is that sort of extra pressure. Let's look at the model code for judicial conduct. So this is from the American Bar Association. I don't believe this is in your book. I don't think it is. I know they mention it, but it's not actually in there. So here is where things can get a little bit tricky. For instance, Canon 4, if you are running for judge in a state or a county that does partisan elections, you have to keep that very separate from other types of political campaigning. You have to be very careful with your funding. You have to be very careful with things like endorsing political candidates, all that kind of stuff. In Oregon, even if you are just a regular state employee, we have very strict rules around endorsing candidates or even things like attending protests, that kind of thing, with your state ID on, with anything linked to your employment, all that kind of stuff. So you have to be very careful with that. Canon 1, impropriety. You can lose your judgeship if you do things that are considered to be improper, and that can be things that are considered morally improper. So if you are the type of person who likes to do a lot of cocaine and have affairs, you should probably not become a judge, because eventually someone will catch you and you will no longer be a judge. You have to be an upstanding citizen. Your personal and extrajudicial activities, you have to minimize any sort of conflicts there. So if you also run a business, you have to make sure that the business you run does not lend itself to any conflicts of interest. You have to declare conflicts of interest. If you're doing a civil case, for instance, between the Department of Forestry and the timber union, you had best not own a lumber company, right? Or you're going to declare that a conflict of interest, you're going to ask for a different judge. All of those sorts of things have to be taken into account. This can also include family members. So you've probably seen some drama in the news around one of the chief justices and his wife's involvement in various political campaigns. That's an issue. That would normally be considered a conflict of interest. And in a different political environment, we would probably see some sort of sanction happening there, or an order to the wife to stop that political activity. So why do some judges act out? According to your book, it's because some stay on the bench too long and it gets to their head. Judicial arrogance. They call it black robe disease. Some of that, there's not a lot of evidence that there is a higher rate of misconduct among judges that have been doing it longer. So I think that idea is mostly a supposition and not so much supported by actual fact or actual research, but you could kind of see where the authors would get that idea. Most of the time it's due to things like politics or funding. We are going to watch a video here from a sort of recent, not super recent. Yes, OPB is my local station. Okay, this here. How do I make you move? Oh no. Hey, I did a thing. Yay. Cool. Nope. The sound's working too. That's exciting. Nobody cares. Yikes.
Thank you so much, Jennifer. The focus is on this one county, Rutherford County, and it's really just only a good point. Some last country, they want to get arrested by the state, another 1,500 detained over a point in time as part of damage, and so it seems like it was subjective. Essentially, at one point, police and judge were deciding on how they put notes or how they keep the passing for moment, whether they would be detained. At the center of the shore, if we arrested 11 children surrounding that idea of a client who was a community. Can you explain that of what happened with those kids and how?
Yeah, thanks for correcting me. Essentially, you said that really well. There were 11 children in all that were arrested for watching a fight. The two that were actually fighting were so young, 5 and 6, that they had culpable reactions of the other children more, and they were arrested under the charge of criminal responsibility because we have findings was not even a real charge. It's a prosecutorial theory. So when can we charge with criminal responsibility? What can we say charge with assault under criminal responsibility? But that's just the beginning of the myriad of mistakes that happen in this case. So yeah, they've got arresting 11 kids in total using this charge. There were 8 kids arrested and handcuffed. A 6-year-old released, a 4th-grader grew up in the assistant principal's office, and she found out she was arrested. It was just a terrible, terrible experience for these children, a terrible moment for this system. Like, it really shined a light on what was happening.
Help us understand how we can't even create this system, an elected judge, and also police officers. How did this happen?
Yeah, so these arrests that you outlined took place in Rutherford, which, as we write in the story, is a completely arresting and jailing kids for years. All under the watch of one judge, juvenile court judge Donna Scott Davenport. She is the county's only juvenile court judge since 2000, when the court began. And she has a really outsized role. She oversees the courts, and she oversees the juvenile things to do. She's arresting police, and what she calls our process for arresting kids, which basically was every child was arrested, even for something minor, like this, like truancy. This was the judge who obviously explicitly said, this is not normal routine procedure for children. Then the second part of this is that once they got to the jail, they were subjected to something called the filter system, which was implemented by the jailer would do. And that was an integrated assessment of what a child was being, whether a child was being right. I don't remember that, but it was really wrong, it was illegal, and it was happening for decades.
You know, there's a lot of discussion about this topic of what incarceration does. The judge in this case, the radio show, that this policy was meant to put parents to kids who come out of this detention system together. What do you find about how kids were affected?
You're not coming out better. Children in so many ways. And you know, the story with this master class, that the children involved in that, many of them have the counseling. They were lucky enough to get acceptance from the county where there was money here for counseling. But I talked to them and they had dreams. They were scared they would get picked up at school and arrested again. And there was another young man who was kept for 4 days and denied his medication for bipolar. After he was released, and he was put on house arrest. And we had police said 3 times in the coming year. So the impact on his children is wide range.
Is this happening? And how are the repercussions for the policy in place?
Some of this has been solved thanks to federal judges when the lawyers have brought access to enforce the filter system to stop, they have forced electric confinement to stop. But the private sector system are setting up. The judge is still the judge, the jailer is still the jailer. And there's also other mechanisms of oversight that.
All right, so what went wrong here? Other than basically everything.
I feel like that's an abuse of power, just because she's implementing all these rules and the person that was being interviewed was saying that it was illegal.
Yeah, so essentially bringing charges against people that aren't real charges. Start with that, that's a problem. And then the second piece, the abuse of power. So sending a memo to officers saying arrest, you know, and we'll talk a little bit when we get to the juvenile justice system section, but we do not jail or arrest children under the age of 7, and from 7 to 14, it's a little contentious. There's a lot of rules around all of that. So if you're arresting 5 and 6-year-olds, that's illegal. If you're arresting them for charges that don't exist, that's illegal. But if you send a memo in writing to officers saying do X, Y, Z, if they don't do it, there are consequences to that. You could be held in contempt of court if you don't follow what the judge says, all sorts of things there. That was from 2020. There were a lot of petitions to recall that particular judge. I don't know what ended up actually happening with it. If somebody wants to find out and put it on their final, you could get a bonus point or 2. Yeah, so that's the thing. There was a similar case in Pennsylvania, my lovely home state, where a judge there was getting kickback from several of the private companies that own some of the juvenile detention centers to send juveniles there. So he was actually getting paid campaign contributions based on the number of juveniles that were being sent to detention. So things like that can happen. They don't happen super often, but those are the sorts of things that people are, you know, human beings like anyone else are subject to, you know, bribery and just all that kind of stuff. So things to pay attention to. If there is judicial misconduct. So first, if it is on a panel of judges, say the state Supreme Court or the national Supreme Court, the chief judge should be the first to address the problem. Every state has a bar association. There's the Committee on Codes of Conduct of the Judicial Conference of the United States. There are all sorts of oversight committees. At the local level, it is a little bit trickier because not all local jurisdictions have that same oversight. You can complain to the State Bar Association. That doesn't always get you anywhere. If they get enough complaints, they'll look into it. In some cases, people will hold a special election to recall a judge. Things like that. In the case we just looked at, federal judges would step in and say, hey, you know, you can't do X, Y, Z. And they have, you know, kind of the overruling jurisdiction there. But even that requires somebody, either the defense attorney or the prosecutor, or somebody to push that case upward. If nobody does that, then the case is going to stay the same. Switching gears here, let's talk about prosecutors. So prosecutors are the gatekeepers because they are the ones who decide who to charge and what to charge them with. So anytime you see a case that says so-and-so versus state of Oregon, or you know, people in the United States versus so-and-so, all that kind of thing, that is originating from the prosecutor. They are there to represent the state or the county or the people or whoever, the public. They work with the investigation teams, and they get to make lots and lots and lots of decisions as well, based on their sole discretion. So they can decide whether or not to charge. You might have a case that looks really, really solid, but if the prosecutor doesn't want to take that case, it's not going to go anywhere. They get to decide the types of charges. They get to recommend, hello. Come on in. Folks, this is Judge Waller. This is my undergraduate criminal justice. We are just finishing up here on the lecture. You are welcome to watch. Sure, no pressure. So your prosecutor gets to decide on plea agreements with the rest of the court team, with the defense attorney, with the judge. They get to often set the terms for the plea agreements. They also make recommendations. So they might make recommendations to the judge based on the type of crime, the seriousness of the crime, all those kinds of things. They can make sentencing recommendations, so on and so forth. Recommendations might not always be followed, but that is part of their role, is they have the authority to make those recommendations. When it comes to actually deciding on charges, so your officer's obviously going to do your preliminary investigation. They're going to gather all the evidence. The prosecutor then gets to look at all that evidence and decide what type of charge, whether or not there's even sufficient evidence to pursue the charges. I love how your book puts this. They can scold officers who fail to do their work. But really, it's more that they can ask for additional evidence. They have a lot of power in terms of gathering evidence and gathering additional investigative work. If they think there needs to be more, they can ask for more. They also interact with the defendants, the victims, witnesses, so on and so forth, before they make their recommendation. So the overarching question is always going to be, can I prove that the defendant committed a particular act beyond a reasonable doubt? So remember Mr. Giraffe and Mr. Lion, and you were asked to be the prosecutor and you had to choose between, you know, voluntary manslaughter or second-degree murder. If you chose second-degree murder, you have to be able to prove that beyond a reasonable doubt. Same with involuntary manslaughter. Some people might opt to go, or sorry, voluntary. Some people might opt to go with voluntary manslaughter because it might be easier to prove with the evidence that was there. Neither answer was incorrect. The actual act could fit both, but you had to look at the evidence and make that decision as the prosecutor. So you have that authority as the prosecutor. Other things that you might take into account are, you know, the prior criminal record of the defendants. Where's my mouse? There it is. The number of counts. So multiple charges, different charges, all that kind of stuff. If there are aggravating or mitigating circumstances, what's going on with the defendants, if they are open to reformation, if you think that they'll go along with a plea agreement, if you think they're going to follow the rules of probation, all that kind of stuff. So you're sort of the first person who makes those recommendations. Mentioned some of these already. The victim's attitude. So be nice to your prosecutor if you get charged with a crime. Because as we saw from the research study a couple of weeks ago with officers, even sometimes the way that you conduct yourself will make a difference. At least in the data, it shows that it makes a difference in how you will be treated in return and the types of things that you will be charged with. Let's talk about defense attorneys. So the main job of a defense attorney isn't necessarily to prove that the defendant didn't do the thing. It's really to make sure that the rights of the defendant are being upheld. So prior to, during, and after the trial, right? We talked about the Sixth Amendment providing for effective counsel. What other amendments do we have to make sure are being upheld? Billy? Okay, which is?
Unreasonable punishment.
Okay, what else? Which other two were on your midterm? Everyone knows because everyone took it, right? You're making a face. Yeah, yep. I mean, pretty much all of them. And not just what we have in the Bill of Rights, but all the other rights depending on the jurisdiction that you're in, making sure that proper procedure is being followed, making sure that the defendant is getting everything they are entitled to throughout the process. So your job consists of making sure the defendant actually knows what they are charged with and what those charges mean, because some people might not know. Making sure the defendant knows their rights. Making sure they are upheld. Making sure they know what to expect throughout the court process. You also need to do some investigative work. So you should have access to all the same evidence. That way everyone is on the same page, and do your own investigative work as well. In some high profile cases, sometimes defense attorneys will even hire private investigators to do additional investigative work. Let's say that they think there's a witness that should have been interviewed that didn't. All those sorts of things. I had a case at the state hospital for a while where they had hired a PI and it dragged on for several years, but eventually found out that that individual, even though he was present at the time of the crime, the PI was able to get additional DNA evidence from a private lab showing that it was not his DNA that was on the weapon. And that was something, it was a small county. They didn't have access to that type of evidence. They didn't have access to that type of technology. So if you're going to murder somebody, don't do it in Malheur County, or do it in Malheur County, depending on how you want to interpret that. But they didn't have the money to basically do that additional investigative work. They just went with the eyewitness, and the eyewitness was intoxicated at the time. And it wasn't until the defense attorney hired a PI to get DNA evidence that they were able to actually have that proof. Go ahead.
So if the defense attorney hired a PI, would they have to submit all the evidence to the PI?
Yep, evidence always has to be approved by the judge. Defense attorney is going to negotiate plea bargains with the prosecutor. And if it goes to trial, they're going to cross-examine the witnesses. They're going to make objections if there are improper questions and evidence, and they are going to present some sort of defense. Couple defenses. You could say that the defendant did not do the crime as charged, which is different than the defendant didn't do the thing at all, right? So this would be, okay, Mr. Lyon did not commit second-degree murder. And here's all the evidence why he doesn't meet the criteria, why the act and the intention did not meet the criteria for second-degree murder. In your mind, you might know that he killed Mr. Giraffe, right? But maybe you don't think he committed aggravated murder, for instance. Some of you actually did say aggravated murder because he ate the giraffe, which is also a fair charge. All sorts of different things you could go with there. You could try to make the victim look like the aggressor. You could try to make it look like someone that they deserved, whatever happened. that there was miscommunication. We see this a lot in sex assault cases, that kind of thing, surprisingly and sadly effective. You can also come up with ways to try to compensate the victim. You can try to settle things out of court. You can try to get a continuance to gather more evidence, or put things off for a little longer. Your textbook writers don't love defense attorneys. You'll notice some of the language that they use here is a little bit different. So really your job is to make sure, again, that defendants' rights are being upheld, but also that innocent people aren't going to end up incarcerated or punished for a crime that they didn't do, or punished for a crime that they didn't fit or they didn't meet the criteria for those specific charges. So they are getting an appropriate punishment for the crime that they actually committed. Does that make sense? A little bit of nuance there. So you have the right to counsel during all critical stages of the proceedings. What that means is that if you have ineffective counsel, you can make arguments based on that as a defendant. This is something I encountered a lot at the state hospital, where defendants felt that they had been that their trial, that they lost their right to a fair and speedy trial because they were listed as unable to aid and assist their own attorney because of their mental illness. And then if the attorney, for instance, let's say you're working with a defendant who's clearly very, very ill, so you as the defense attorney trying to protect their rights, you put in a recommendation to the judge that they be assessed for illness and for trial competency. And the psychologist who assesses them says that they're not trial competent, even though you're protecting their rights by making sure they do not go through trial while they are still experiencing intense mental health symptoms. The defendant might not feel that way. So they might still try to argue that you were not effective counsel and that you violated their right to a fair and speedy trial. So there's lots of different nuance here. One strategy that a lot of folks will use, I see this a lot with folks that have more serious crimes that end up incarcerated, is that they will file a writ of habeas corpus, basically saying that I don't think I got the trial that I deserved, and that will delay their incarceration further. And depending on how the judge or the jury has ruled their sentencing, that delay in of itself might count toward their sentencing time. Other folks hanging out in the courtroom, your court reporter, your clerk, and your bailiff. These are the more low profile, but they are present during proceedings. They can be present during plea negotiations. It's not always like it's on TV where everyone just gets together and like meets in an office or whatever. These are folks that are there to record, to document, to make sure things are happening correctly, to make sure there's order, to make sure there's, people are being civilized, so on and so forth. These are also the folks who are responsible for making sure warrants and subpoenas and all of those things are done correctly and delivered in a timely manner. So if I do a court order that says, hey, the county has to respond within 72 hours, these are the folks that make sure that actually happens. Well, they make sure it gets to the county in time. For folks that are interested in working in courtrooms, these are also really, really great roles to start out in. All right, we're going to talk real quick about defenses some more. And then you're going to have a break, and then we're going to have Judge Waller take the floor. So affirmative defenses, this is yes, I did it, and here's why. It could be yes, I did it, and I would like to do a plea deal. It could be yes, I did it. In Oregon, GEI, guilty except insanity. Or yes, I did it, and here's why I'm not responsible. This could be our self-defense. This could be all of those kinds of things. Yes, I did it, but I'm 5 years old. You're laughing, but ideally that person would have an attorney saying so for them. Or like in the case we saw in the video, not so much, but We have a whole list of laws and applicable tests for insanity. Oregon Revised Statutes, Chapter 161. There is a link there that you can read. And when you see those orders, they follow exactly along. So I will receive a piece of paper that says ORS 161.370, which is committing somebody to the state hospital for trial competency restoration. Most states have some sort of insanity plea, but Oregon is kind of unique in the way that we do ours, which we will talk about here in a little bit. Originally, the insanity plea started with the McNaughton rules in 1843. This was a case where he tried to kill the prime minister, accidentally killed someone else. And the two main questions, and there's kind of a whole list of rules. If you look them up, you can find, you're not responsible for knowing them. But basically, we apply a set of rules to each case. And here it's, okay, did they know what they were doing? And did they know that it was wrong? Two different things. Because somebody might know, okay, I killed that person. I knew that I was killing them. Did they know that it was wrong? Maybe their illness told them, you know, maybe they were having some kind of delusion where they thought that that person was someone else. So two totally separate things, as opposed to, did they know they were doing it at all? Everyone knows about the John Hinckley Jr. case, yeah? Does anybody not? No, a couple knows. John Hinckley Jr. is the fellow that tried to assassinate Reagan. Really, really, really high profile case. He was released just a few years ago from treatment. What's that?
Oh, no, I just realized what this guy did.
Yeah. Lots of new precedents were set by his case. So things can get a little bit messy with insanity defenses. The messiest thing that happens is, let's say somebody has some kind of mental illness, but maybe their symptoms are not what actually caused them to commit the crime. That gets sticky. We see this a lot in Oregon, where we have so many folks that are struggling with mental illness because maybe they're not trial competent, but they're still criminally responsible for the actual charges. So we have rules around what it means to be criminally responsible. We have rules around what it means to be mentally ill, what types of mental illnesses are accepted, what types of symptoms of what types of mental illnesses are accepted, and criminally responsible gets sticky. So is the person criminally responsible if they had the illness, but they chose to stop their medications? All sorts of questions there, and every single case is kind of treated uniquely. So things can get really, really messy with these. And justification and so self-defense. Lots of folks use this on their midterm, so it has to be proportionate to the threatened harm. I know we talked about this with use of force with police as well. So if somebody's yelling at you because they're angry, you're probably not going to shoot them, or at least you shouldn't. If they have a gun, then you might be able to argue self-defense. Necessity in the event of an emergency. Can anybody think of a time where you might commit a crime out of necessity?
If you're giving someone CPR, you're always gonna have to break the ribs.
Yeah. So we do have, Good Samaritan laws around that. You didn't assault them. You were saving their life. Others can be a few years ago, and I don't know if it's still a thing or not, but in Oregon, there was a law passed that you could break windows if there was a dog inside, which I think is fabulous. Like if it's hot and you want to save the dog. But this can also be more serious things. Like let's say you're at the prison and escaping is a felony, but it's flooding. And so you leave, or you find a way to leave, or whatever, things like that. And duress. So this is where the defendant claims they committed the act only because they were not acting of their own free will. I haven't seen this used often, at least in my work, but I'm sure it exists somewhere. And last but not least, excusable. So age, entrapment. Intoxication is another iffy one. This is where we look at criminal responsibility. So you were too drunk, you committed a DUI. We look at whether or not you should have known to get so drunk that you could not drive, or choosing to drive while drunk, those kinds of things. So defense, anyone under the age of 7, they are too young to form the requisite mens rea. What does that mean again? It was on your midterm. Latin. Anaya? So Latin for of a guilty mind, which is what? The act and the, yeah, motive and intent. So if you're under 7, you are considered to not be criminally responsible because you are too young to have the act, the motive and the intent. 5 pocket constitution. From 7 to 14, it gets a little sticky. Prosecutors have a little bit more power there. They can try. 14 and over do not have what's called the infancy defense, but are typically tried in juvenile court. And in some states, they can be tried as adults. Just depends on the state, the county, jurisdiction, prosecutor, all that kind of stuff. Entrapment. Everyone knows what entrapment is. Okay. So being induced to commit a crime that you typically would not because of some kind of police action. All right, let's take a 5-minute break and then we will have Q&A with Judge Waller. Lily, you still with us?
Yes, I am.
Gosh, okay, cool.
Oh, gosh, it's so bittersweet. I like excited the statue, but yeah. The whole thing is just. Yeah, of course, yeah, it's always hard to, well, especially it's one of the bubbles. Yeah. Nothing's gonna be really help. Yeah.
I'm very fun. All right, is everybody back? Did everybody sign in for attendance?
All right, if you didn't, then I have it here. Did anybody not? All right. Okay, I'll start back here. Then pass it up. So this is Judge Nan Waller, Multnomah County, and I will let you introduce yourself however you please, and I will sit over here and keep my mouth shut. Because I have bronchitis.
I've been on the bench for much longer than any of you have been alive.
We should have one student on this.
Okay, for probably for more than 30 years. And I'm going to tell you a little bit about my background because I think it's helpful in terms of understanding that there are many paths that you can wander down in terms of your careers. I worked as a lawyer first for legal services in Montana. Legal services represents indigent people. I wanted to do public service work, and I moved from Oregon to Montana to do that. And when I moved back to Oregon, I worked for the public defender's office in Portland, representing adults charged with crimes and representing children in dependency and delinquency cases. So kids who where there were allegations of abuse and or neglect of children. I represented the children, I represented their parents, and then on the delinquency side of the juvenile court, representing children who would have been charged as crimes if they were an adult. After I'd worked as a lawyer, we were expanding our family, and I decided, my husband's a lawyer too, and we decided, well, we probably, one of us should be home more. And so I said I would, and I stopped working, which I can still remember the day that my 2-year-old was at the bottom of the staircase having a temper tantrum. And I thought, oh my goodness, I really miss working. And so a friend of mine who was a judge said, would you volunteer as a juvenile court referee? A juvenile court referee is a judicial officer. They hear cases like a judge. And I was a pro tem judge at that point. And I said, oh my goodness, that would be amazing. Thank you. If I could do it part-time, that would be great. And so I started volunteering, and after a few months she said, you know, we could pay you, would you like to be paid? And I said, well, if I could work half-time. And I thought, this is a great gig. We had 2 more kids, so we had 3 children, and I thoroughly enjoyed it. In order to work half-time, it's a job like that, it really is more than half-time. It's more like working a light full-time, but it gave me some flexibility, which is what I wanted at the time. I didn't have any expectation that that would lead to being a judge, because I knew I had taken an alternative route by not working full-time, by deciding to. And the first time I went for, when you're appointed a judge, there are lots of interviews and investigations that go on, and there were other people who had their names in. And one of the other applicants came out of the interview room, and the whole panel of people doing the interviewing came out from the governor's office and from private firms, and said, this person knew his wife worked as a teacher where my kids were all going to school. And he said, oh, well, there's Nan Waller. She is always at the school. She is always there volunteering. How do you have any time to work? And I was just mortified, because here he was saying it. And then I was mad, because that was a crass, horrible thing to say. And it was very sexist to say, you know, how could you possibly have time to work? What he didn't say was that I would go and volunteer at 6 in the morning sometimes to help with a big mural project. And the governor didn't even ever ask me about the fact that I'd been working in a half-time job. He said, can you continue to be as involved as you have been? And I said, absolutely, it's what I like doing. The thing that I love the most about judging is what I see on the bench can inform the policy efforts that I work on off the bench. There was a time when judges called the balls and strikes. That's what they did. They sat on the bench, they called the balls and strikes, good for the day, gone. Judging has changed over the years, and I don't think if it hadn't changed, I would have been as interested in being a judge. Judging now is, there's the Chief Justice of Michigan said that judges have an ethical obligation to do more than simply sit on the bench and call the balls and strikes. The judges have an ethical obligation to try to work on improving the system and what they see in front of them. Right now, I've done everything on the bench. I did juvenile, I did family law, I've done civil, I've done criminal. I was the presiding judge of our court. I was the chief family court judge. What I do now, I think, has been the most compelling aspect of my time on the bench. I do everything at the intersection of behavioral health and the criminal justice system. So I hear all of the cases where defendants are unable to aid and assist. I do all of the cases where defendants have a mental health disorder and they are willing to be in a treatment court. So they're willing to come to court every week, be on probation, be involved in treatment. And the social policy issues are unbelievably enormous, because when people are in the criminal justice system, that adds an extra stigma to the fact that they are mentally ill, which is unfortunately in this country, there's a lot of stigma around mental illness. And it's almost impossible sometimes to get people into the services and treatment that they need. We are in Oregon, we are 50th in the country in terms of access to treatment, and almost right down there, close to the bottom in terms of outcomes. The people I see, nobody's going to pick to be in their treatment program because they are involved in the criminal justice system. Sometimes they are disorganized. They have been living on the street often. This is the work that I think I've found the most compelling, the most urgent. I was on a webinar today. I think there were 1,000 people from around the country, because there was just released the National Center for State Courts. I was on a national task force in state courts response to mental illness, and a phenomenal amount of work came out of the task force that was finally released today. And so if you have an interest in mental health and the criminal justice system, it's a great, amazing resource, the amount of product that's produced. But that's kind of my story in a really small nutshell. I will say one thing that your book has wrong is I have no bailiff in my courtroom. I have no court reporter. There are no court reporters in Oregon. People who want to hire a court reporter can do so. Everything is recorded on, and if people want to know what happened, then they can get the recording. But those are all things that have happened primarily as a result of budget cuts. Now, that doesn't mean that there aren't other new things that weren't previously involved in the criminal justice system. The public defense offices now they're trying to hire social workers to be part of their defense team, because it's understood that simply helping the person with the case that they have isn't necessarily going to help them not come back into the criminal justice system. And that should be the goal of everybody. It's certainly my goal as a judge. People not recycle back through the criminal justice system. And so having a social worker who can help develop a treatment plan, having a community law project associated with a defense office who can work on things like eviction or family law matters that are going to be areas where the person is likely to have difficulties. If people don't have housing, if people don't have, they aren't able to get a job because of they're being denied employment because of their criminal history. Those are all things that can be helped, and there's a recognition that that criminal defense shouldn't just be, I defend you on the case and I say goodbye, because very likely under those circumstances, you'll be saying hello again in pretty short order often if people issues that led to their involvement in the criminal justice system haven't been taken care of. So this is your time to ask questions, and I'll answer any questions that you have, or I can keep on talking if you don't have questions. Yeah.
I don't know if I'm wording this right, but do you experience like prejudice thoughts while like judging defendants?
Do I have implicit bias that implicit bias is something that judges talk and study a lot, because every single person has implicit bias. All of us make automatic decisions based upon the cultural norms. I mean, when I was driving here today, I didn't have to think, all right, keep my foot on the pedal and look every once in a while around. You do those things automatically. And implicit bias it acts in the very same fashion. It is, we are all creatures of our culture. If you haven't taken the Harvard implicit bias test, it's on your laptops. Have you taken it?
They got bonus points if they took it for their midterm.
Okay, I would urge you to take it. Take it multiple times because there are different aspects to it. So I've taken it over the years. Plus, you're then part of this enormous research project, and always disappointed in myself, when I take one on race or ethnicity. And so a couple of years ago, I thought, well, I'll take one that I know that I'm going to do well on. So I'm not completely biased. I don't have implicit bias that affects all of my thoughts. I'll do one on gender and career. And I came out with women being more associated with home and men being more associated with professions. And I was so disappointed. I mean, I've worked my entire life. My mother worked. And so to me, it was a good lesson in the absolute nature of implicit bias, that it just seeps into us. We don't have any control over it. There's a lot of work being done right now on how we can control implicit bias. And there are some things. I just was at the judicial conference and there was a wonderful speaker, Dr. Andrea Miller, who does a lot of work on implicit bias in the courts. And we know that if you have an overload of, you have too many cases and you have too many things going on. I mean, every judge, we don't have files anymore. So when you're the PowerPoint was talking about, getting all the files and everything is on my laptop and on my computer screens associated with my laptop. So, people are messaging during the day because they need help with something. My staff is trying to get a hold of me. I'm trying to deal with the people in front of me. And what they found from a lot of the research is the cognitive overload. You're more likely to fall back to implicit bias if you're not kind of aware. They've shown that, if people are hungry and tired, so after lunch, probably not, right after lunch, not the best thing. Having too many cases on your docket, not the best. Our court participated in a research project probably 10 or 15 years ago, along with courts from Los Angeles and the small court, I think was from someplace in Minnesota. It was a juvenile court project looking at, could you reduce the impact of implicit bias in removal of children from care of parents based upon race, because we know that there's disproportionality in the juvenile justice system of removal of more children of color than not. And so it was an actual, the gold standard type research where there was a control group and a research group randomly assigned. And the research group were given a script where you were supposed to solicit more information about the parents who are sitting in front of you. And on the premise that the more information that we have about people, the less that automatic implicit bias is going to take over. And in fact, that's what the research showed. So we've moved in the criminal justice system from lawyers negotiate, they still negotiate, and they still do it over the computer screen or over the phone. But there's much more in terms of having the defendant in the courtroom engaged in the settlement conference so that everyone can learn more about the defendant. And hopefully some of that helps with that taking the time, being aware. So of course, I'm human. And so yes, of course, I would be a fool to say that implicit bias would never be. But one of the other things that they've shown is helpful is being aware of it. The more you're aware, then the more that you can make sure that you're putting safeguards into place so that you limit the impact of implicit bias. It's a long answer to your question, but it's something I've done a lot of work around. I have a question for all of you. What's the most important thing when people come to court? Do they want to win? Is that the most important thing for people who are seeking out, whether it's a family law case or a civil case? Is that the most important aspect of coming to a criminal case? Justice, and what does that mean?
Making it fair for everybody, whatever way that is.
What they've shown in research is distributive justice, did you win or did you lose, is less important than procedural justice, how you ended up feeling at the end of the day. And that when people are given a chance to tell their story, when they understand what is happening, when they are treated with respect, when they believe that the person making a decision is a neutral, objective decision maker, they can lose and feel better than sometimes if they win and feel like they haven't understood the thing that has happened, or they haven't been allowed to tell their story about what is going on. And so how we treat people has an enormous impact in terms of confidence in the courts. It's really, what authority do I have as a judge to make sure that people are doing what I order them to do? How do you think I go about doing that? I mean, I always could say, you didn't follow my order, I'm going to place you in jail. Is that the best way? No. I want people to understand that the authority of the court is such that people should obey. And what they found through the research on procedural justice, that if there is procedural justice, if people perceive that they've been treated fairly and have had that opportunity to have their story heard, and they're treated with respect, they are far more likely to follow court orders than not. So be nice and think about it when you go to the, if you go to the, I guess people don't go to banks anymore, but if you go to the store and you're trying to get some information from somebody, you're trying to negotiate a return, and all you're getting is somebody handing you off to the next person and not helping you and being impatient. Even if, or you have somebody who's going out of their way to help you, even if you can't get a return, but you understand what happened and why and what's going on, the likelihood is that you'll walk away feeling okay about it, even if you didn't get what you wanted, which was to return whatever you no longer wanted. So you surely must have some questions. This is probably one of the few opportunities you can just ask a judge anything. Doesn't matter what you want to ask me.
Today.
Yes.
So we talked about some of the challenges when it comes to being a judge with psychological discomfort and loneliness, like not being able to talk about the cases. How do you cope with those kinds of issues?
Say that once again, though. I missed the first part.
We talked about the challenges of being a judge, psychological discomfort, loneliness when it comes to like not being able to discuss cases with like outsiders kind of thing. So like, how did you come to cope with that?
Well, one, I have a lot of colleagues and we can talk amongst ourselves, which is great. And I also, I love the work so much that I don't really feel very isolated. I have a good, there are lawyers that I've gotten to know over the years. We don't talk about the cases, but it's not a sense of loneliness. Yes, I sit on the bench by myself and I make decisions, but there are a lot of people around me who both are going to provide me the information that I need, the lawyers appearing in front of me. I have good staff who I can talk to, and I have now all judges, we're all connected we have a same time function on our computer. So I can ask 37 other people, or actually 176. I'm connected with all of the judges in Oregon. And if I'm really stuck, I can reach out, not to have them make a decision, but if I just need help in terms of something.
Do you have any words of advice for someone who is coming into that field?
Into law? I was certain when I knew that when I started off, legal services seemed like it'd be really interesting, and it was. We were kind of big fish in a small pond. I was writing right out of law school position papers for working on them for a US senator. I was the president of of our local chapter of National Association of Women. And when I moved back to Oregon, I thought, well, I should do something that's really a, more grown-up job. I'll start interviewing with law firms, with big civil law firms. And the first civil law firm that I went to, the partner that I was talking to said, you've been doing some pretty amazing litigation. I mean, in Montana, I look back now and I think, oh my God, I can't believe the things I was filing, the civil rights lawsuits and various things. And are you really going to be happy being an associate? And I said, no, you're right, I'm not, which is why I ended up at the public defender's office. Try things out, not because you think they're the right thing, but because it's something that you have some passion about, and then be willing to change if it doesn't work. Keep an open mind. Be involved in more than your job. I say to all young lawyers, get involved in the bar association, get involved in activities in the community, because you want that full perspective and of how things are impacting the work that you're doing. Watch in court. Being a clerk, we still do have clerks in our courtrooms. Being a clerk is a great first job right out of law school, because you get to see a whole variety of lawyering styles. So you can kind of figure out what you really dislike and what looks at, and you can figure out what kinds of cases. I mean, we, have all judges, most judges have a variety of things coming across their, into their courtroom. And so you can kind of get a better idea if it's something that interests you, or you just think, oh, that's not what I want to do at all.
I don't know if anyone else has turned out. What's the day-to-day work look like when you're not in the actual courtroom? Or is that where?
Well, I'm in the courtroom a lot. I was in my courtroom until 5 o'clock today, and before I jumped onto the very slow freeway between here and Portland. So today I had 2 hours in the morning that I was scrambled to get through somehow my email just, it grows faster than anything I've ever seen, and to respond to people. And then we had a meeting, which you'll appreciate. There's federal litigation going on right now as far as the state hospital and admission to the state hospital, and admission to the state hospital is now being run by the federal courts. As part of the litigation, it was suggested that we try as a pilot in Multnomah County, having all of the different stakeholders at the table. So we have social workers, we have people from the county behavioral health, we have people from corrections, we have the coordinated care staff from our local CCO, Care Oregon. We have people from the programs where people who are mentally ill and unable to aid and assist can be placed. We have people from Oregon Health Authority, people from the state hospital, and we take difficult cases and try to come up with solutions. So we spent an hour on one case. Usually we do more, but this case was especially tricky in terms of trying to come up with a solution for this individual who was in jail and taking medication, but not taking maybe quite as much to really be stable. And what we always want is, when we release people into the community, we want to have them have a chance of doing well. So with 20 people on a screen, we spent an hour problem solving about what could be done in order to get the information that was needed in order to get him to a therapeutic bed in a it's called CATSI. It's a residential treatment program, so that he could really be stabilized before being placed in the community. I then was on my webinar with 1,000 people, which was pretty exciting to talk to 1,000 people that I couldn't see. And then I spent the rest of the day, 4 hours, dealing with people who were very mentally ill, coming into the courtroom and trying to make decisions about where they were going to get treatment, whether at the state hospital, whether in the community, whether their cases were going to be dismissed. When somebody is found who's found if it's found that will never be restored, they will never regain competency. And competency is based upon the Constitution, due process. You have a due process right to understand the nature of the proceedings, to be able to work with a lawyer and to be able to make decisions. A lawyer doesn't make the decisions in a criminal case. They follow the lead of their client and can't make the decisions for their client. And as you probably have read and heard and probably talked about in this class, we're in a crisis right now. The numbers of cases in Oregon where people who are in the criminal justice system have competency issues has gone up as it has in most states. So this isn't an Oregon specific problem, it's a problem around the country. And there are a lot of theories as to why. Probably the best theory is in 1963, President Kennedy was going to reform the mental health system. And there were two parts to it. One was to close, used to be lots of big institutions, warehousing of people who are very mentally ill or people who had intellectual disabilities. And Oregon had Damage, and they had an institution called Fairview, and those have all been closed for years. The second half of President Kennedy's plan, so that happened, where 95% of large institutions around the country were closed. Second half, to create a network of community mental health, never really got off the ground. And I think that what we are seeing right now in terms of the numbers of people with significant mental illness, Oregon is about 50th in the country in terms of access and bad outcomes. And so we are struggling right now in Oregon. And boy, if you, there is such a behavioral health workforce. So if you go into anything to do with behavioral health, you become a social worker, you become, there is work to be had. And there is a tremendous effort right now to increase the workforce, including making more money being put into what people are getting paid, because that's been one of the issues, is that people should be able to do the hard work and get paid a living wage. So that was my day today. Tomorrow, I think I spend all morning hearing a case where the person is at the hospital and not willing to take medication. And when somebody is not willing to take medication under by statute and originally by a US Supreme Court case, which is the cell case, the prosecutor can apply for a cell order, an order to allow involuntary medication of somebody where the government's interest in prosecution of the case is great. So it has to be a serious, and oftentimes it's a serious charge. And serious charge is defined through case law as something where the person is going to be facing up to 5 years in prison. There's a lot of case law around it. And there's no other means to restore the person to competency. Some kinds of mental illness, medication is incredibly helpful. Schizophrenia, you can do a lot of talk therapy, but that's maybe not going to get the person to where they need to be. And so it allows a judge to decide, which is, I think, a pretty, I take very seriously the decision as to whether I'm going to require that somebody be forcibly medicated. And there are factors that you have to make findings about. So that's all tomorrow morning. And then I'll be doing settlement conferences in criminal cases for mental health court, where people are asking to be taken into mental health court. For the population that I see, for many of them, the alternative is prison. So it's either they get into mental health court, or then the offer is going to be an offer of prison. We take only high risk, high need people. And the reason for that is, again, I'm a strong believer in research. The research shows that we should put our focus on those who are high risk, high need. We get the best outcomes. And the reality is that most people will get out of prison. We don't have many people living out their lives in prison. And so, especially for people with mental illness, we know that being in prison is not a therapeutic setting where people are going to usually get better. Oftentimes people deteriorate in terms of their mental illness. And so when they come out, they are in worse shape than when they went in. And that's not to the benefit of the community or to the individual. So that's, I think, most of tomorrow.
Lots of meetings, lots of.
I have lots of meetings. We work hard. I can make lots of decisions from the bench and I say, this is it, the decision is made. Judicial fiat in terms of changing systems does not work. The only thing that works for that is collaboration and mutual respect amongst all the systems to respect each other's mandates. So I can't order the DA's office to not prosecute certain crimes, but I can sit at a table where we realize and talk together about, along with others, that really sending somebody who has criminal trespass charges to the state hospital isn't going to make a lot of sense, because the maximum time they could be at the state hospital is 30 days, and the state hospital costs upwards of $1,500 a day to house somebody at the state hospital. And so, and 30 days isn't very long to restore somebody to competency. The flip side of that is, and this really is an illustration of what we don't have in our communities. I had a gentleman it was last year, where he had a delusion about the Portland airport. And every time he would get released from custody, he would head to the airport where he would create a big scene, and which would make life difficult for all the people who are simply trying to get to their flight. So he'd be arrested, charged with trespass, again, a Class C misdemeanor charge, maximum penalty, 30 days in custody, driven the 12 miles from the airport to the jail, appointed a lawyer. The lawyer would meet with this individual and determine that he had concerns about his ability to aid and assist. An evaluation done, which is forensic evaluations. That's another great field, forensic evaluation. There's a big need for forensic evaluators in Oregon.
Majors in this class?
Oh,
Yep.
boy, you are wanted in our community. You have lots of choice ahead of you in terms of what you're going to do. And then the evaluation would come back and say, oh, yep, he has a qualifying mental health disorder. He's unable to aid and assist. And everyone would say, well, this makes no, and he's too disorganized to be restored in the community. We try to get people the services and treatment and housing in the community to restore them in the community. So what would happen then, do you think? Everyone would agree the charge should be dismissed. Well, after 70 dismissals of criminal trespass charges, when you think about what the cost of that was, a deputy driving him down the 12 miles every day, every time this happened, I mean, that was a horrible example of what is lacking in our community. What would have been the better thing to have happened to this guy? What if there'd been services in the community and somebody who had to do outreach, not waiting for him in his very delusional state to show up at an office and say, I have an appointment today. Was that going to happen? No, he was too disorganized. But if somebody had had the responsibility of doing outreach to him and trying to engage him, we might have had half a chance of getting him to a point where he wasn't going to be going out to the airport every time that he got released from custody and ending up causing a fuss. The sad part of the story is that as he cycled and cycled back through, and at the end of the day, we dismissed 70 cases, he finally deteriorated to the point where it was believed that he could be civilly committed. So out of the criminal justice system to the civil system, where the standard for civil commitment is somebody has a mental illness and it creates an imminent threat to themselves or others, then they can be civilly committed. The bar in Oregon is pretty high for civil commitment. There are 7,000 plus notices of mental illness filed in Oregon every year. Of that, about 541 people are committed. About 1,000 are diverted, which means they're going to be kept in treatment for 14 days and then hopefully stabilized to the point where they can function. So that's about 5,000 people who somebody at a moment in time thought were at imminent risk to themselves or others because of their mental illness, that nothing happens. And so that's that whole group, or people who end up then sometimes when, you know, the officer in the middle of the night, somebody who's having a difficult time in the middle of the street, impeding traffic, where do you think they take that person right now? What are the choices?
Well, we had some officers here a couple weeks ago that talked about because the jail beds are so taken that they also don't take them to jail.
Sometimes they don't take them to jail. Sometimes they take them, sometimes the only place to take them is jail. The emergency rooms are all filled and turn away many people. There should be options other than that. So there are lots of people working on in Portland building a assessment and stabilization center, an alternative to jail that would be able to provide make easy access for first responders and law enforcement or mobile crisis to get somebody someplace where they could be provided the care and support that they needed, and hopefully keep them out of the criminal justice system. So I have one of my mental health court participants, when it was really cold, was either last year or the year before, was during the height of the pandemic, so maybe it was 2 years ago, came into court one day and he looked horrible. And he said, didn't have court, didn't have a hearing. He said, "Judge," I happened to be on the bench, "Judge, take me into custody." And I said, "Well, you know, what's going on?" And he said, I'm in a crisis." And I said, "Well, tell me a little bit more." And he said, "I'm in every kind of crisis, emotional, physical, mental." He had been, he'd gotten kicked out of his housing because he'd used, and he'd been out on the streets for several days. The weather was sub-zero weather. He was dehydrated, he was hungry. He'd lost his medication. He suffered from schizophrenia. So as many people do, they self-medicate, and it's also dangerous to sleep at night on the street. So people take meth in order to stay awake as a safety precaution for themselves. So we started making phone calls to see who. There weren't many public buildings open. The courthouse was one of the few public buildings open during that period of time. So we had people coming to stay, you know, to sit in the courthouse because it was warm, it was safe, they could fall asleep and, you know, nobody was going to do anything. And so we let him rest in the conference room on the floor, got him some food, started making calls, and pretty soon a crisis response team did come. And they assessed him and they made the arrangements to transport him to a psychiatric hospital to see if he could be admitted. And he looked at me and he was very grateful and said, "Thank you." And then was very prescient and said, "They will not keep me. I will be out tomorrow and back on the street." And he was right. And that's been repeated time and time again. As a judge, that's a really hard thing to watch. To see somebody who can identify who's begging to go to jail. I mean, he burst into tears when I said, "I have no basis to take you into custody." Because he knew, I mean, for him, that was the only solution left. He'd gone to 4 emergency rooms the day before and gotten turned down by everyone. They all knew him. They were all familiar with him. To me, that is in terms of, you know, if he'd had a heart attack, we would have had people, Johnny on the spot, taking him someplace and getting him what he needed. We do not have the same regard for mental illness and people who are in a mental health crisis. And instead, you know, you've all read the paper, some of you maybe live in Portland or see what's going on in Portland. People are very upset that a lot of people are living on the streets. Most people don't want to live on the streets. Some of them don't want to live in congregate care shelters, given their histories of trauma. But, you know, we haven't made the investments over the years to get them what they need in order to be able to live the kind of life that they want. And I think that we have so isolated people with mental illness. How many of you have seen somebody who's really having a hard time as they're walking down the street and they're talking to themselves, and seeing people with their phones out filming because they think it's kind of funny. You know, the people I deal with are very, very lonely. If you haven't had a chance, watch Hiding in Plain Sight. It's Ken Burns. It's his first part of his series on mental illness that will go over about 10 years. It's a remarkable piece. It's not about the criminal justice system. But for all of you going into psychology and interested in that, it's a wonderful piece about, and quite frankly, if you're interested in going into the criminal justice system, it's a great piece because you realize the stigma attached to mental illness. And then when you add the stigma of being involved in the criminal justice system, 70% of the people in jails have a mental illness or a substance abuse disorder, or many of them both. 70%. Our jails have become our largest mental health institutions in many communities. And that, from my perspective, is not okay. I believe strongly in public safety. I don't think, you know, we should have had an alternative for the guy who kept on going out to the airport. He was creating a public disturbance, but having him go to jail time and time again doesn't really work. Having people end up in the criminal justice system and not having the treatment and the housing in the community that will accept them, and having the only option be prison is not acceptable. So I hope that all of you will consider, because I think that there's just, you know, there's a world of work to be done, both in the criminal justice system. There are a lot of good people trying to change how the criminal justice system works so that it's more equitable, both in terms of race, in terms of mental health. You know, I think that when we look at marginalized communities, those with mental health issues are definitely a marginalized community that we need to make sure that there is good equity for.
Have you noticed any changes in the mental health population and sort of the way that you're able to make rulings, and getting people the help they need as a result of Measure 110?
Not directly. Well, Measure 110, people believe that it legalized drug use. And there should have been, somebody missed the boat in terms of not doing a better social marketing campaign. It was intended to decriminalize or not be able to use jail as the hammer to get people into treatment.
I'm going to interrupt you. How
Yeah.
many of you are doing your projects on decriminalization versus legalization of either illicit substances or sex work? More than that. Okay, so pay attention.
But the people that I see coming in front of me, I always try to talk to people and get them, you know, going in terms of explaining what they want out of life, because we know that the more people are engaged in their own life, the more that they are likely, and that they actually have some goals for themselves, and they have some things that they want to do, that it's really important. And when people say things to me like, well, you know, I haven't tried meth yet, and that's on my list of things I'd like to do, I think, oh my God. Or they say when they tell me they've used fentanyl, oh, well, it's legal. And I say, no, you're missing, that's not the message. You can't be taken to jail simply for using fentanyl. But that does not mean that it is okay for you to be using fentanyl, especially for people on probation. But I think that I understand the motivation behind Measure 110 of decriminalization, not just using jail as the hammer when people are in possession. But we are just awash with meth and fentanyl and opiates and heroin, and people are using up the wazoo. And it is not a good thing for our communities at all. You probably all know, you know, you're of an age where you probably are aware of people. I'm kind of I see it all from my bench, and it's pretty ghastly. I hope that people your age are not just seeing Measure 110 as the ollie oxen free, do whatever you want. That would be horrible, because I'm terrified, and I've lost, as probationers, a number of people who've overdosed. I mean, we keep Narcan in our courtroom because I'm so terrified that somebody's going to come in. And people do come in where clearly they are very high. and have been using, and then they say, yeah, I did, I used, and I think, oh God, you have no idea what you're ingesting at this point. The rate of deaths from fentanyl is horrifying.
How do you balance something like Measure 110, where the idea is that we can mandate people to treatment, with something like actually charging somebody and putting them through substance use orders into a diversion program? Or do you still have the authority to do that?
Well, we still have drug treatment courts. It's not dealing with the charge of possession of methamphetamine. It's dealing with the charges of unauthorized use of a motor vehicle, but the person has a significant substance abuse that is then leading to involvement in criminal activity. And so that's how we're kind of getting around it. But Measure 110 has not resulted in, it's early on, so hopefully things will change, but it hasn't led to, the $100 fine has not motivated people to engage in treatment voluntarily. And clearly we haven't had enough treatment in the communities, but there was a great, during legislative days, between legislative session, they have legislative days where they have committees that meet and people provide testimony about how things are going. And there was one on Measure 110 a few weeks ago. And there was a professor or a doctor from OHSU and a professor from Stanford who both testified. What really stuck with me in listening to them was when you're saying to people, $100 fine for using or being in possession of methamphetamine, there's no incentive. People feel good in using meth. Meth grabs people's brains and their pleasure centers, and it feels good, and you have to keep using to continue to feel good. And he said, there's no incentive to get treatment if people are using because it makes them feel better than where they have been. You have to have something that's going to either engage people or require people. And I don't think we're at that point yet. Hopefully we will be.
Working with so many, especially in the behavioral health and the mental health population, how do you kind of personally, from the bench, balance issues of individual rights, like the right to decline treatment or the right to not engage in treatment with, mandating things? And that's kind of what we saw with deinstitutionalization, right? Is that we don't want to require people to essentially be warehoused in these really, really horrific types of institutions. And yet now they're, out on the street, living in the gutter, in the rain and snow, so on and so forth. So how do you balance, individual rights? The whole idea was that people have civil rights. People are allowed to deny treatment. People are allowed to decline medication. People are allowed to decline going to the emergency room, so on and so forth. How do you balance that with, say, public safety, or deciding, well, this is for the good of that person, even if there are a psychiatrist, I like to quote Dr. Torrey. He wrote Surviving Schizophrenia, if you've read it, but he said, well-intended but grossly misguided civil rights activists who want people to be able to make those decisions for themselves and yet are clearly putting themselves into danger. So if you have to choose, for instance, between trying to get somebody civilly committed versus waiting for them to commit a crime and they get committed that way, how do you kind of balance those issues from the bench?
Well, when I'm on the bench, I follow the law. That's my job. And, if there's some things I can order and there's some things I can't. I can't order somebody to take medication unless they have medication prescribed. If they're on probation, I can order for mental health court, take your medication as prescribed. And then, we do have people who tell their doctor, stop prescribing, I'm not going to take my medication. And we've gotten into some interesting discussions about whether that's really in their coming into mental health court and asking to be brought into mental health court, whether that's really in keeping with the commitment that they made. I think that for many people, I've discussed with lawyers from Disability Rights Oregon, the ACLU, on where should that line be in terms of people's individual rights. When people are in meth psychosis, they are not often capable of making any decisions. When people are living on the street, I thought I was going to have to go, I do jail side hearings when people are refusing to come into the courtroom. And the deputies say that they'll have to use force to get somebody into the courtroom. The deputies don't want to do it. I don't want them using force because somebody is likely to get hurt, either the deputies or the individual. And so we go jail side to do hearings. And there's a unit of the jail in Portland where the most mentally ill people are held. And it's an assault on every sense in walking through the doors. People are standing, sometimes naked, catatonic, not moving. People are screaming. People are spreading feces. People are really having a hard time banging their head against, the wall. One, I'm not quite sure how anyone who's really mentally ill in that kind of an atmosphere can function at all. It's hard to be in there, for 15 minutes, and I know that I am going to leave, and I can be outside, and I can have cool air, washing it all away. But I don't think that most of those people, and I've talked to people both while they've been in that state, and then I've talked to them after, where sometimes people are just so, people come into court and they apologize to me for how they were acting. I say, oh my God, you don't need to apologize. You have a mental illness. Thank goodness that you made some decisions to start taking medication and to working with treatment providers. And how are you feeling now? So I think there are a lot of people who don't have the ability, they lack the capacity to make a decision and to choose to live, on the street, or choose to be spreading their, one poor woman was so embarrassed, and understandably, she, had been thinking that her feces had magic powers, and so she, was trying to do her hair with it, and she was caught either that, or she'd read a report, was cognizant after she started taking medications and really stabilized and just was doing great. And she said, I'm so embarrassed that happened. And I said, you have an illness. It's like, if you have high blood pressure, you're not choosing, your blood pressure to shoot up. You need medication in order to control it. It's not something you can just wish away. It's the same thing. And I think that that's part of the stigma with mental illness, is that, nobody stares at people who have diabetes and have to take insulin. People don't go, oh my God, let's cross the street. People do that with people with mental illness. And so I think that there's a big difference between people having voluntary choice, which I think all of us are for voluntary choice in terms of how we get health care, or how we get mental health care, or the choices we make in terms of where we live. But I think that it's clear that there are people who, especially the combination of substance abuse and mental illness, where people don't have the ability to make a voluntary choice. And at that point, we need to be able to step in and help them get to the point where they can resume having control over their own lives. And it's hard as a judge. Sometimes there's not a darn thing I can do. We can't proceed with a criminal charge. They don't meet the bar for civil commitment. And it's nothing worse than kind of saying, I had to commit very serious or dismiss very serious charges for a gentleman recently who was never going to be able to be stabilized. He'd been institutionalized for a while, so he didn't meet the bar for civil commitment. And I said, okay, and everyone agreed there were no other options except to dismiss his very serious Measure 11 charges. He said, well, I'm going to dismiss your charges. He'd been hospitalized for a couple of years and in custody. And he looked at me, he said, now what do I do? And I thought, oh my God, what kind of a community are we that's where we leave him? He recognized, he had no place to go. He had no housing. There wasn't anyone who was going to provide it. So please, all of you people who are thinking about entering behavioral health or criminal justice, we have a crisis in behavioral health workforce. We have a crisis in public defenders. We have a crisis in people in our jails, and we certainly have a crisis in terms of employment at the state hospital. So you all are very much wanted in a lot of areas. You should make good on that.
So if you're thinking that, like, to get to people that are in jail for those mental health issues, to get them out and for people like the guy we were just talking about, a better solution would be for us to make kind of like a more severe mental institution.
No, I don't think, no, I think that there should be some place for him to go that provides support for him. There should be an option for somebody who has serious and persistent mental illness to have lifetime support, not just for the length of time that their criminal charges exist, because, you know, when that goes away, when that support goes away, then people deteriorate, you know, and I hope to God he does okay. But I think that it doesn't have to be more severe. It can be, what we should offer is, you know, a caring community that provides a place and ongoing support, somebody who will help him case manage, not just for the life of the case, not just, you know, but for a long time. He'll always need some support. So I think that we could do that if that's what, you know, we could prevent a lot of people from ever coming into the criminal justice system if we had more community support and providing it in a way that people can get it. You know, right now it's, if you want to, you have to show up for an appointment at a certain time for a community mental health program. And if you're somebody who's been living on the street, and you don't have a watch, you don't have a house, you don't have anything, you know, the likelihood of not always showing up at the right time. And then oftentimes, you know, programs, oops, you've missed, you know, 3 times, you're out, you're closing your case. Instead, it should be something flexible. There's a model called the CCBHC, Community Behavioral Health Center, and it's integrated health, physical health, mental health. And a lot of around the country, not so much yet in Oregon, but around the country, the CCBHCs are providing that much more flexible administration of healthcare and behavioral healthcare. And they're using it a lot with both treatment courts and the criminal justice system. I have a lot of people who, you know, if you have an arson charge, getting you into housing is almost impossible. Getting you into a residential treatment program, can't do it. And, you know, the legislature did not decide that everyone with an arson charge automatically is going to go to prison. There are, you know, possibilities they're not, but it's very hard to find housing, which then puts people who are high risk if we don't have housing or somebody who will accept them. I think that there probably there's an entitlement to healthcare, including mental health care. And I think that people know that we should be doing something in order to assure that that is provided to people who need it.
And keep in mind, Medicaid recognizes 7 different levels of behavioral health care, everything from inpatient, something at the state hospital, to completely on your own. And if you have somebody who's in a situation where they can be ordered to one of those levels, let's say we have somebody who is adjudicated guilty except insanity, and we say, okay, well, they start at the state hospital, where do they go from there? You know, people can make recommendations and then the judge can order, well, they can go to a secure residential facility or a residential facility, or maybe they're ready for outpatients, or maybe they're ready, you know, different levels of services within that system. The problem that we face is that not every county has those levels, and some counties are less receptive. For example, I went to a community meeting a few years ago in Washington County. They were trying to build a community mental health supportive housing, and community members were there chanting burn it down because they didn't want it built in their neighborhood. And that was in response to a 2011 case in which a gentleman living at a housing first model, so a model that didn't require specific types of treatments, broke out in the middle of the night and raped a little girl in Hillsborough. And so because of that case, the community was not open to having any other similar facilities, even though it wasn't the same type of facility, and, you know, all of those different kind of moving pieces there. So in order for, you know, in order to send people to those types of places, they have to exist, and the community has to be open to having them exist. There's a case right now, some of you have probably seen in the news, gentleman being released from the state hospital to Woodburn to a secure residential facility. Secure residential means that it's a locked door. You don't go anywhere without staff. You have to earn privileges to go different places. And folks in the community still do not want this individual there because of the types of charges he got. Even though, in order for him to be released in the first place, he would have to go through numerous assessments proving that he is no longer a danger to himself or others. there's a lot of just misconception, lack of education, and also just fear, right, in the community. If you see those folks out on the street, most people think, well, I don't want that person to be my neighbor, without realizing that that person would be very, very different if they were housed and getting the treatment needed. Things are, there's a lot of moving pieces there.
And we absolutely have to be concerned about public safety, but I think that when we don't have the appropriate placements, then we are really not being at all concerned about public safety, because then we have nothing. And I think that that's a horrible position to put both the community and the individual in.
Any other questions about that? Have you found that you're treated and responded to differently than a woman? Being a woman who
at various times, yes, absolutely. When I first became a lawyer and I was in Montana, my very first client, or maybe it was my second client, I met him and he said, "Oh my God, I don't want a girl for a lawyer." And I'm not usually fast on my feet, but I just looked at him and said, "Well, thank goodness you do not have a girl. I'm a woman." And one of the first times I went to court, the judge said, "Oh, I'm sorry, the legal secretaries can't come in front of the bar." Things have changed drastically since then, but there are still times when absolutely there is, that implicit bias test, the one that I said that I thought I would pass with flying colors, career and gender. Now, there's still a lot of sexism, but it's not, for the most part, no. We have in the bench in Oregon, the bench in my court, I'll speak to that, is more than, it's 50% women, 50% men. We have great diversity on our bench. Governor Brown that's been one of her big things, to have a diverse bench that reflects the communities where people live. And the Supreme Court in Oregon has, I think it's more than 50% women right now. So I think we've made tremendous progress, but those implicit biases are still there sometimes and get in the way of how people interact with each other. Well, I hope that all of you will do good work. There's nothing better than having a job that you love. And there are a lot of things outside of work that we all need to sustain us. I am incredibly grateful that I have a grand family and I love them dearly. But, at the end of the day, having work that you love and work that is worthwhile, I think that that's, for me anyway, that's one of the most fulfilling things in my life, to feel like I maybe, hopefully, am making a difference in some people's lives, maybe bettering the systems that people are having to travel through in our community. So I wish you all well. It was good to see you, not on a screen.
Thank you very much for being here.
Yeah, absolutely. Take care and good luck in all of your studies. Are you all, what year are you? Various.
Very diverse class this
year.
Yeah.
Try out various things.
Well, I was gonna say, we have a criminal justice minor, we don't have a major.
Uh-huh.
So we have lots of different programs that people can bring here.
Well, there are a lot of things in probation officers, also an area where they need to hire a lot of people. So there are jobs for all of you in the justice system or behavioral health system, because in all aspects of both, there are far too many job openings. For our court, there are great jobs in our court. We have 40 job openings right now, 40. So if you are close to graduating and you want to try out.
Yeah. Multnomah County have mental health TM specifically yet?
Yeah.
Awesome. Okay.
Yep. I have 3 probation officers in my mental health court, all of whom just deal with people who are very mental health. Very helpful.
Thank you.
Thank you.
All right, folks. So a couple people have emailed me about doing some group time. I do have that little into the schedule at the end of the term if you would like, you can spend the rest of today doing that as well. So who would like to do that? And then we'll vote on once we vote after that. Anybody want to stay and like exchange numbers, get emails, figure out what you're doing for your focus group presentations?
Yeah, can you put the names back on the board?
Yeah.
Yeah, the list is on Canvas. It's okay. Thank you so much. Drive safely. That was one of the things that came up on the little blue sheets, was that apparently I'm not super clear about what's on Canvas. So please, 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 if you're ever looking for something and you can't find it, ask me. And if it's not on Canvas, remind me, because there's a good chance that I put it on Canvas and then forget to hit the little like green checky box that makes it live, which is really a stupid feature. I don't know why that exists. Excuse me. All right, yeah, the list is on Canvas. You should all have each other's emails. George Fox should just auto-populate. Okay, you're grown up, she'll figure it out. And then I will have the rubric up when I'm no longer dying sometime by the end of this week, hopefully.
What is on your sweaters? Like, what is the?
Oh, they're little skulls. It's from a brand called Skull Cashmere, which is lovely and like this weird niche thing. And all they make is cashmere with skulls on it. It's great.
I'll take one. Yeah, exactly. I was often staring at like the.
That's fine. That's fine. Oh, goodness. All right, Lily, your classmates have opted to be done for the day, so get a hold of folks on group from the list on Canvas, and hopefully we'll see you next week.
Okay, thank you. And you said the list